Hey, good afternoon, everyone. In Introduction to Law, I'm going to try to cover chapter, I believe it's 14 on business organizations. Chapter actually goes a lot broader than business organizations, but there's some important information there that relates to business law because that was the last chapter on contracts. But oftentimes, things about agency, which we start with, will be found in chapters more related to employment law and things of that nature outside the scope of the business entity. But nonetheless, it's important to go over these concepts. So the chapter does start with what agency is, and basically the rawest definition of what an agent is when another party is engaged with the principal to enter into contracts, has the power, or at least the apparent power, to enter into contracts on behalf of the principal. So there's always three parties involved. There's the principal, there's the agent, and then there's third party where the contract will be made by the agent for the principal. Different ways in which agencies are critical in the business world. Think about it. As a sole proprietor and a small business owner, you might be able to do all of your contracting and management yourself. Very small operation. However, you may have employees. Employees are not always agents, but sometimes they are. Sometimes people who are agents are not employees. But what distinguishes them is that they have the power to go and act on your behalf so you can get things done. You can't be in multiple places and entering into contracts to run a mid-sized business or a business that has significant complexity without having people go out and enter into contracts on your behalf. The easiest way, or I shouldn't say the easiest way, the best way to create an agency is with express authority. You overtly retain someone and hire them. You have to compensate them. That's implicit. So even if the contract orally or in writing wasn't clear about whether or not you were going to compensate them, you have to. And the compensation will be based upon the nature of the tasks that historically get paid in that realm. There's the sort of the business judgment of the past pattern and behavior of what agents would get paid for those kinds of services and work. So that's pretty clear. So what can an agent do? Agent can do almost anything that the principal could do if the principal is there on his or her behalf. There are some limitations because of either law or public policy. So I can't hire an agent to go out and vote on my behalf. I can't have them go and serve on jury duty for me, or if there was a draft to go serve in my behalf in the military. I can't think of them all, but use your common sense. An agent should be able to do all things related to contracting for a business unless prohibited strictly by law or those that we consider to be too personal to be delegable to an agent. And I don't know them all, but it's just an introductory concept that I want you to keep in mind. So those are express appointments of agent. Many agents are more by implication. We don't overtly talk about it, we don't express it, but over time, the principal's engaging someone to go and enter into contracts on their behalf. That's an apparent agent, and they have apparent authority. They're cloaked with a certain amount of authority that would be reasonable for the third party to conclude that they do have the power to act on behalf of the principal. And why do we care? Well, because if they either have express authority or if they have apparent authority based upon the circumstances that surround the situation, it's going to be reasonable to bind the principal into the contract. Of course, the agent has to reveal to the third party that I'm Jim Corman and I'm an agent for Mount Wachusett Community College and I'm here to buy office supplies for the college campus. Now, if it's true, or if it seems likely I do have that power, maybe I have some kind of ID that says buying agent from Mount Wachusett Community College. I don't know what it would take to make a reasonable seller of goods to believe I was clothed with appropriate authority by Mount Wachusett Community College to enter on their behalf. If you're the third party, you always want to confirm that does this person actually have authority from the corporation or from the other entity or the individual, because if they don't, you go back to the principal, try to bind them. If there's not enough either express authority, maybe they have a power of attorney where it's written out that gives directives to third parties showing that Jim Corman can enter into these contracts on their behalf, or there's enough apparent authority that, maybe I pull up in a big truck that says Mount Wachusett Community College on the side, and I say, yeah, I'm the buying agent from Mount Wachusett Community College, and I have a uniform. Maybe they have, badges and IDs that look official. and those were all given to me by Mount Wachusett Community College, it might be reasonable for that third party to believe I have the ability to bind the principal into that contract. But you can see there's some gray areas there. So that's why it's always good if it's a significant contract and you're that third party, you want to make sure that the individual or individuals, if we multiple people involved, actually have the apparent authority to act on their behalf. You can imagine someone saying, I'm Tim Cook from Apple, or I work for Apple. Tim Cook's appointed me to do certain things, and we'll get into that in a second about corporations. Well, a corporation has to have corporate resolutions and votes to authorize different people to do different things. And maybe you're a company that's going to supply glass for the surfaces of an iPhone, and it might be for millions and millions and millions of dollars. Do they really have the authority and power to enter into that kind of contract? It's a real issue. So there's express, overt, and real authority, and it might be in written form, it might be in oral form, but between the principal and the agent. What's the principal's duty? To compensate and reimburse the expenses of the agent, long as it's in the course and scope of the agency. What's the agent's duty? It's fiduciary. They have to hold the principal's interest in the highest regard, and they have to supply information too. So say I was an agent on behalf of a group that goes out and purchases investment real estate, residential real estate, 3-deckers and things like that, apartment complexes. And I'm to go out to look for prospective pieces of real estate to encumber with a contract to buy on behalf of this investment capital group. One of the things that's very, very important is that the seller of those buildings want to make sure I do have that actual power to do so. And power of attorneys written up might be a big help in that kind of regard. Now, when it comes to that information, say I'm out there and I'm looking for different apartments and buildings and things, and say I'm doing pretty well financially myself, personally, in my own personal way, and I come across the deal of a lifetime for a beautiful multifamily that's been very, very well kept for years, and the price is just, I've been able to negotiate an incredible price. Can I basically say, well, I'm just going to buy it for myself? No, because it violates my fiduciary bond, if you will, my trust that I have with my principal. Now, what if I told my sister about it? She's into real estate too. And I said, hey, Patty, I know I'm working for, BlackRock investments in here and stuff, but there's a deal you can't pass up and it's right in your neighborhood, so it'd be easier for you to manage. Can I do that? No. Could I just not report it back? No. You have to disclose information as an agent to the principal to see what could possibly serve their best interest. And it's really like the attorney-client privilege, relationship, doctor-patient. You owe the highest degree of care and concern for the advancement of the principal's interest. And again, the principal has to reimburse you for any cost or and compensation as well, as long as it's in the course and scope of the agency relationship. Agency duties, principal's duties, types of authority. Actual authority is the big one. What do you have the right to actually do based upon what the principal's granted you? And then the other ones are implied. So you might have certain actual overt grants of authority to go do things on behalf of the principal, but some are implicit. It just goes hand in hand with the nature of what you're doing. It's kind of like saying you have you're an agent and your role is to bring a boat from California over to Massachusetts shores. You obviously have implied authority to be on that boat, and maybe even sail it, and maybe hire a crew. If you don't know how to sail, to hire a crew to do it. It might not have been over. Just go and get that boat and bring it here. Well, there's only certain methods you can do that with. You obviously have implied authority to make, whether it's trucking, if it's available to go through trucking, or hire a crew to sail it over here to the United States or to the eastern seaboard on behalf of the principal's request to have you do that. So implied authority gets very, very nebulous. And then apparent authority. Sometimes businesses, individuals make it appear to the world that somebody is in their employ as an agent and has the power to act on their behalf. If you do that, even though they don't have any actual authority, it's basically I don't want to say a pretend situation, but it's a false read by third parties. But if you've clothed and you've made the world believe reasonably that that person does have the authority to act on the behalf of the principal's liable. And the principal, the third party needs to know that me, Jim Corman, I am Jim Corman, agent for Acme Industrial Supplies. If you just go in and say, hey, I'm Jim Corman, I want to buy a bunch of supplies and I enter a contract, the principal might not be liable in that situation because it's not apparent to the third party that I'm acting as an agent. In fact, if you sign contracts, you should often do that. Jim Corman, agent for Acme Industrial Chemicals. Why would I do that? Because now I won't have personal liability in that contract. Very, very important. Inherent authority. And then sometimes there's no authority. You're just a rogue person out there. And maybe you have some relationship with the other individual, but you go out and try to, I'm just thinking about my friend who did that recently, bought me some tires and rims for a car I have. And he didn't ask me ahead of time. And at first I was really mad until I brought them over, and they're very, very nice. And I did a little research, and they're probably just the deal of a lifetime. I'm very, very happy. And so if a person acts as an agent and seems to have apparent authority, the principal, even though there's no authority at all, either inherent or apparent, the principal can ratify, and now the contract is basically bound between the principal and the agent. So that's a perfect example of that. Now, respondent superior. Principals are agents are liable for agents' conduct, and they have to reimburse the agents for their losses. The only little weird exception is, say my agent is out and they're driving the car negligently and they get an accident while in the course and scope of their agency trying to promote something on behalf of me, the principal. I'm liable for all their medical bills and things of that nature, as long as they weren't at fault. They get hit by a drunk driver. But if they were negligent and they were at fault, I have no obligation to reimburse. Now, but what if they were negligent? They went through a stop sign because they were texting and weren't careful, and they damaged somebody else's car and maybe injured that person. I'm liable to that third party, but I can, because of respondent superior, sometimes called vicarious liability. It's very similar to an employer-employment situation when it comes to liability for agents. Course and scope employment. And I think we're about to jump into the different kinds of business entities. Unfortunately, the book puts a chart back in the very beginning of the chapter that's really fantastic, talking about how many people can be involved in the different kinds of businesses. And they go through the big four. I wish they went through another one called a limited liability company. They do mention it, but that's growing very, very rapidly and very, very popular in terms of structuring a business where it has its own business entity, can own property, can sue, can be sued, but it has a lot of flexibility for the owners of it to run it. And it's a pass-through for tax liability purposes, and it protects the members, the owners of the limited liability company from personal liability. That was a lot, I said really fast, but the point is on the chart, it's 14.1 on my book, it's page 518. It really does a nice little chart talking about the different parameters. And I know you shouldn't memorize all these things at this early juncture on a survey course, but you should know there's a lot of different entities a business could either create or become when they start doing business. So the first one, which is the biggest area law, sole proprietor. Sole proprietor can actually be a very large company. It's simply what? Owned and controlled by one person. Sole, individual. Usually don't have to do anything to create a sole proprietorship. You don't file paperwork or anything like that. You might have to get a business permit for the town or municipality you're in. And if you're not going to use your own actual individual name, you might be required to do something called get registered as a fictitious name registration. This is because if you go out in your company, say I'm Acme Chemical, but I'm Jim Corman. I own the whole company. It's my company. I have a lot of employees and I have a big building, and we're manufacturing, supplying, and packaging chemicals for industrial cleaning. I don't know. I call it Acme Chemical. Now, if I cause injury or I'm going to be sued on a contract, I am individually responsible. Acme Chemical isn't a corporation. It doesn't have its own legal entity. It's a mirror image of me, but it doesn't say Jim Corman Chemical. It says Acme Chemical. To protect the public, we often require, in most municipalities, in most states, someone to file a fictitious name registry to show that Acme Chemical is owned by Jim Corman, so that way they'll have the ability to serve me and tax me. Potentially real estate and actually personal property that's in a business entity gets taxed too by most municipalities, towns, and cities. That surprises a lot of people. But that fictitious name registry, it's not a big deal. You can do it online usually. And the same with pulling a permit to run a business. This is something that requires a certain degree of discretion by the management of the town. You want to open a liquor store, you might have to get a liquor license. They might not want so many liquor licenses in town, or they might not be authorized to issue so many liquor licenses. So it's not always that simple. But for the most part, I'm going to open up a landscaping business. How do I do it? I go get a lawnmower and a truck, and I start looking for people to mow their lawns and charge them the money. That's a sole proprietor. It can become big. It can become very, very big. I was just talking to I wasn't talking to my father. He passed away, but my father's closest friend's kid, who's about 10 years older than me, he started doing like a lawn mowing business when he was, I think, 16 or 17. And then when he got his first license, they got a pickup truck, he got some riding lawnmowers, he got a trailer. And then before you know it, he had a whole, I think he franchised it actually, did extremely, extremely well, but he never ended being a sole proprietor. And one of the things you worry about, why would he? Well, sole proprietorships, you're liable for anything that happens within the realm of that business. You're liable for your employees' misconduct that injures or harms other people's property or persons. You have to have workers' comp on behalf of them. And if there's, negligent actions have been done by your employees or your personal assets are at stake. Now, that sounds terrible. No one would, I don't want to be a sole proprietor. That'd be awful. To risk, because there is a lot of risk there. Well, it depends on the nature of the business you're in. One, how much risk is really involved. But two, there's always insurance available. So I don't always dissuade small businesses from necessarily running away from the sole proprietorship entity. Why? Because it's so easy to manage. It's so simple. It's a pass-through entity, meaning that the entity really doesn't exist other than the purpose of identity, but taxes only get taxed once. You get taxed on the profits you make. It's a pretty simple process. And you get tax deductions for the amount of money you invested in the business to run it. Sole proprietorship. I'm a sole proprietor. My law firm's a sole proprietorship. A lot of attorneys will open up LLCs. And I did one time, and I let it lapse. I closed it down. I dissolved it because I found that the filing fees in the reporting requirements just didn't seem to make a lot of sense. And I carry malpractice insurance. So I didn't feel there was any need to put either a corporate identity. And you can do a professional corporation. It's not even in the book, but it's just an earmark for pass-through. It changes a little bit the nature of the corporation. I just don't see a need for it. And I don't think there's always a need for it for smaller businesses where there's not a great deal of risk or where there's insurance involved. Sole proprietorship's ease of management is the main attractiveness to it. You can just start doing business. There's no licensing requirement from the state to create the entity. Partnerships, general partnership, and I've been in one of these before too, 2 or more people get together to start running a business for profit. And there's no end date in sight. If it was for just one project, say myself and 3 other attorneys got together for a big lawsuit against, I don't know, some big corporation or something like that, but we're not going to maintain a relationship after it other than that one project. That's not a partnership. That's actually a joint venture. I don't know if I saw that in the book, but a joint venture is the same in terms of legal identity for that one project, but it's not a partnership because it doesn't have, no end date in sight. It's just clearly delineated what it's for. And then if the people stay together and keep working on other projects, they've turned the joint venture into a partnership arrangement. You don't need a formal partnership agreement. I always advise you to have a partnership agreement because this is what happens most of the time. People that decide to become partners are good friends, sometimes family members, and they're all getting along, and it's great. Then you're running a business, and people have different ideas about how it should go or how it should be run, and that can create a lot of friction and problems, and the partnership will ultimately dissolve by one of the partners quitting or multiple partners quitting. It's very easy to set up a partnership. You just start doing business 2 or more people, and it's also very easy to dissolve, but that creates a lot of problems with future contractual relationships you might have had because you can own property in a partnership name, and you can also be sued or sue on behalf of the partnership. But when it's so easy to create them and so easy to dissolve them, I highly recommend having a partnership contract, if you will, or a management agreement, because who's going to make the decisions? What happens when major or small decisions are made? Should it be just a majority? Should it be a super majority for other decisions? And who's going to run the day-to-day operations, if anybody? Or is there going to be a team of the partners that are going to basically run certain things? And I always give the class, when I teach business law in class, we're going to, one of my million goofy dreams, but one of them is to own like a little antique shop with really good gourmet coffee that's roasted right on premises. And then I'll do it with 3 or 4 partners that have that kind of like vision. And next thing you know, we're selling some really crappy books that I don't think is appropriate for the kind of genre I was hoping to set up there. And then the coffee, I have a vision of what gourmet coffee really is and roasted on site. And I come in one day and I see, we're selling popcorn flavored coffee, and there's an opportunity at the end of the line to get Sanka or instant coffee, and I'm appalled. Well, if you are in a partnership, all the partners have equal say in how the business is going to be managed or run, unless you have a partnership agreement controlling that. And things do. I've been in partnerships and law partnerships with very close friends, and they're still my close friends. But boy, you want to risk losing friends being in a law partnership where you have different visions about what space you should rent, whether we should hire more attorneys to work for us as employees, how many paralegals, how many secretaries, the kinds of ways we're going to advertise. It can be very, very controversial and very, very painful. So I think when you have an agreement like that, it could help at least make people understand how the processes are going to work, because any general partner has the same power to act as any other partner to make decisions about how the business is going to be run and move forward. And what's the big drawback? Well, that's one of the drawbacks of partners is you have to make sure everyone's on the same page, or one partner could really throw things off. The other is unlimited liability is a danger. If one of my partners goes out and does something negligent on behalf of the partnership interest, I am liable not just for my investment in the partnership, but for my personal assets as well. Again, insurance would help me sleep easier at night in a general partnership. But each of us being able to make, or multiple, it could be 5, 6, 10, 20 partners, or it could be just two. When it's two, it might be more easily managed, or three. But what happens when you get 20 or 30 partners, you may want to have that partnership agreement ironed out in terms of creating a managing partner that makes a lot more of the day-to-day decisions on how things are going to be run. The other benefit of it is the ease of startup. It's great. And also the pooling of capital. I might be the brains behind how to run a criminal law practice, but I don't have a lot of cash up front. Another attorney might have a fair degree of wealth, and they might not be necessarily the most skilled yet as a lawyer, but they want to partner up with me. Maybe that's the way we contribute initially is, my experience, and his or her financial commitment will help sometimes move things forward. And pooling of money is always a powerful tool to advance business interests. Now, what is a limited partnership, also sometimes called the silent partner? That's where there's two groups. Me, you, and Fred, the three of us are going to be general partners. We're going to run this show, but we need more money. Well, other people think it's a great idea, but they don't want to get involved to the running of the daily business or make any business decisions. But boy, they'd really like to invest in this opportunity. Those would be the limited partners. They would invest money. The amount of their risk is capped at how much they invest. That's why they're limited. They have limited liability. Here's the thing that's dangerous. Imagine investing $100,000 in this new limited partnership. You're not going to have any management say whatsoever. Other people are going to manage it, and you're really excited about the investment. Couple of years in, maybe you're doing okay, making a little profit, and then all of a sudden comes along, kind of weird business decisions are coming out of the partnership. You think it's going really poorly. Can you start making suggestions and getting a little bit involved in the day-to-day operation of the partnership? No, because once you breach that limited silent aspect of the partnership and become active in the participation of the management, you've converted yourself into a general partner. Now you risk what? Liability for any of the partnership's debts, negligent actions, things of that nature. And that's the whole reason we were trying to avoid it by the investment alone. And that does happen a lot too. Relationship with the partners, partnership property. You can own the partnership property can be named in the individual partners, or it can be named in the partnership. The partnership, some law firm, Smith & Jones, might have 10 partners, but it has the name Smith & Jones. Real estate could be owned, and things can be owned by Smith & Jones as a partnership entity, but we know all the partners have an equal interest in that real estate, or things too. How long does a partnership last for? Until one of the partners leaves, or until there's what we call futility, meaning the partnership can't make money anymore and there's no hope it can ever improve. Now, what can often happen is 2 or 3 of the 10 partners branch off and they just go create their own new partnership. So one is dissolved and a new one's created almost in the same moment. I don't want to get too deep into that. Dealing with third party. It's important also, say a partnership dissolves and I'm with 10 other people and the partnership's dissolved. I'm scared that those other partners are going to go out and create more debt that I'm liable for in the partnership name. So sometimes when partnerships do dissolve, and same with corporations, they often give notice out to entities they usually do contract with that partnership's now dissolved, and you will not be liable for anything that they encumber for debt. And it's a boring chapter. It's long. In a termination and dissolution, any one member quits, the partnership is over. It doesn't mean the other 9 or 10 or 3, whatever's left, can't just start right up in their new partnership. And then there's issues about who gets to keep the name. And then there's lawsuits over, well, at that moment that I quit, we've got to figure out the valuation of what the property, the partnership owns and has vis-a-vis its debt, and I get paid out. And now if they don't have the cash, the court will often give them a period of time to pay out my interest. But the concern is a lot of times when somebody quits and when the partnership's dissolved, it's like they act like you're unplugging life support. That's really not true, because the other members, they don't continue under the same partnership. They create a new partnership. But what if they want to keep the name because of the goodwill and stuff? Well, that has to be kind of negotiated with the person that's left. Partnership agreement would resolve that right from the get-go. You say, well, how do I do one? Well, there's models out there, there's form books, there's practice manuals on how to create a partnership agreement for functionality and how to do work. You look at models and examples, there's a lot of them out there. And then you Frankenstein them to fit the purposes for your clients on what works best. Corporations. There's 2 major kind of corporations. There's the classic C Corp, which is the corporation that's going to issue stocks, and it's not always easily tradable stocks, by the way. I'll get to that in a second. But the power of a corporation is the pooling of assets. You want potentially an unlimited number of people to potentially invest in it, but you want to have it geared towards a specific purpose. But you need the government now to sanction you to exist in this realm of corporation. And so what you do is you have to create a set of bylaws for what the corporation does and how it's run, and whether or not you have a board of directors and how many. You have to outline with some degree of specificity what the purpose of the corporation is for. Is it to buy and sell real estate? Is it to run a law practice? Is it to run a medical practice? Is it to run a landscaping business? So the government knows the parameters of the nature of the business you're entering into. And then you fill out this thing called Articles of Incorporation, listing the goals of the corporation, how many shares of stocks will be ultimately issued, who's going to own them initially, how many are going to be retained by the corporation, whether or not they can be openly traded, whether it's a closely held corporation and you need consent of the other corporate members to sell, and under what circumstances a stock can be sold. Not everything's like you see traditionally in popular culture, where every corporation is traded on a public exchange where you can buy and sell shares. Most corporations exist closely. They're family businesses or groups of people where the stocks in the ownership interest are curtailed in how often and when those shares of stocks can be redeemed and sold, and to whom. So there's a lot of control in a closely held corporation. But in a traditional C Corp, the big benefit is, by investing in it, the most you can lose is your investment. You don't really have any ability to run the organization other than to vote for the board of directors, and the board of directors picks the leaders of the corporation that's going to run the corporation. And some of them could be board of directors, not only on the board of directors, but they also could be the CFO or the CEO, things like that. Like Elon Musk is probably a major shareholder in Tesla. I know he is, but he is also, I believe, the CEO of the company, basically the chief running officer, and he's probably on the board of directors, but he controls the board of directors. How do you control the board of directors? If you own shares in stock, usually you're a voting member by owning shares in stock, and you get to vote at the annual meeting on who the slate of candidates will be for the board of directors. And if you don't own a majority of the shareholders, you're going to have a tough time controlling the path of the trajectory, if you will, of how the management will work. You're probably, something like Tesla, you're going to be probably just a pure investor. You're not going to have a lot of say because somebody will have a majority of shares, or a group will have, and sometimes people will team up with other shareholders to try to create a bit of a cabal, if you will, to have influence on creating who the board of directors will be and how the management of the corporation will go. So the big benefit, you have limited liability. The big weakness of it is lack of management. You really have very little control over the corporation, and double taxation. A C corp gets double taxation in that the corporation makes $10 million profit this year. Well, then they have to pay corporate tax on that profit. Now you, as a shareholder, may get dividends, or your stock may grow, and you may sell your stock and make profit. The profit on the sale of your stock is taxable, so there's a second tax. And then if you get dividends, that dividend is taxed as capital gains. So a C corp has double taxation. An S corp is a better way to go. And most small businesses opt for that if they're going to go in the corporate route. An S corp is just basically recognized by the IRS as having no more than 100 shares. It's a fairly small business in the big picture thing. It can have a number of employees, but it's smaller in terms of its impact on commerce. But it's only taxed once. It's a bypass entity. So the corporation makes $100 million profit. It's not taxed until it's distributed to its shareholders, and then it's only taxed at that juncture. So it's a little bit better tool. But the same concept of having articles of incorporation, seeking a charter from the state government, and having a set of bylaws on how the corporation is going to be run, all have to be done in order to get that charter from your state. A lot of people say, why does it seem like so many corporations are doing business here in Massachusetts with its primary place of business in Massachusetts, but they're incorporated in Delaware? It's cheaper and easier. It's really what it boils down to. So if a corporation is incorporated in another state, but primarily doing business in this state or some other state, that's called a foreign corporation. Terrible term because it makes it sound like it's from another country. It's from another country. It's an alien corporation. It doesn't prevent it from doing business. Under the Privileges and Immunities Clause, any business can pretty much do business in any other state, but they may organize in a foreign state, or a different state, I should say, to make it easier for you to understand, because of the ease of the paperwork and things of that nature. Doesn't mean you're not going to pay taxes here in Massachusetts. The life of the corporate, unlike a partnership, when a partner dies or leaves, the partnership ends. With a corporation, it can, in theory, last for all eternity because shares are exchanged and sold. Now, be careful when especially if you're new to this stuff, you might start getting into investing. Not every corporation has shares that are traded on the stock market. Those are what we call public corporations. That's actually not many are, just the really big ones are. Most corporations aren't openly traded. So if you hear about a company doing really well, you find out who the owner is this corporation. I want to buy some shares of it. Where do you go? Well, you probably have to contact the corporate leadership to say, I want to buy some shares. They may sell them to you. They may have the right to issue some basically corporate held shares because they're trying to raise revenue for a new expansion. And they can offer new shares out to, but they can decide who they want to deal with and who they want to give shares to. And then it doesn't necessarily pay dividends. Not every kind of stock is a dividend-bearing stock. You have to look into it. It's called a prospectus. When you're buying shares of stock, they have to provide you whether it's a dividend-bearing stock or if it's a value stock. A value stock is what's a value? I think Amazon's a value stock. So if you invest in Amazon, the way you make money is you hope you buy it at $300 a share. You hope that someday when you decide to sell it, it's $350. So you made a $50 profit for each share you own, but you don't get dividends. A company can convert and eventually give dividends. And then there's all kinds of different favoritism for different kinds of stock. There's participating stock. There's so you get like 7% participating. I mean, you get the first 7% profit through a dividend prior to the owners of common stock. And participating means you get to vote. Some stocks are non-voting. You can buy a stock and you don't care about the voting. You're in it for usually a little cheaper, but you don't get any participation in voting for the board of directors. I know, I'm boring the hell out of you. Ownership versus control, statutory requirements, types of corporate statutes. Oh, and if you don't, and that's the other thing too, that reason why I usually steer my clients away from, sometimes I shouldn't say steer them away, I'm not too keen on it. You got to file a tax return for both partnership. It's called an informational return because it's a pass-through entity. Partnership doesn't pay taxes, but it's informational. So that way they know, oh, this partnership made $10 million. And then they say where it was distributed to the different partners. And then the partners pay taxes on their individual tax returns. It's part of a way to keep track of where money is flowing. But on both an S corporation is also pass through, but they have to file a tax return, and so does a C corp. And you have to keep corporate books, and you have to have corporate meetings, and you have to behave as a corporation would in terms of holding yourself out to the community as a corporation. If you fail to do so, you lose your corporate identity, and somebody could sue you and say that the corporate veil of protection should be pierced because they didn't maintain the entity as a corporation, which is a legal fiction, and they shouldn't be able to benefit from the protections of a corporate entity. I don't want to get too deep in it, but it's just an important concept. And now the LLC, which the book does not talk about, the LLC is very similar to a corporation in the sense that you're only liable for the amount of investment you put in the LLC, but it's a much simpler document and entity to create with the Secretary of State here in Massachusetts, and every state. It's a very simple form. And you don't have shareholders, you have what's called members, and they have the same kind of risk, only to the amount of their investment. And they can, the LLC can own property, can sell property, can be sued or be sued, but they're not going to go after your personal assets. But it's a little easier, in my opinion, to do the paperwork and create the entity, and the requirements on tax filings, I think, are much more simple and that's why it's growing so rapidly. It's very popular. I think it's fairly new, unless it just caught on in the past 10, 15 years. Stock subscription, security exchange, voting by shareholders, dissolution of the corporation. If the corporation finds for whatever reason it's going to dissolve, what they do is they pay all just debts and liabilities, and then they sell all their assets and they distribute what's remaining to the shareholders based upon per capita ownership. Pretty straightforward. The shareholders, bankruptcy. There's a couple different kinds of bankruptcies. I don't want to get too deep, but an individual can file bankruptcy, and that stops any creditors from going after them. But to meet eligibility, you can't have a ton of money and file bankruptcy as an individual. But you can usually retain your primary home if it only has so much equity in it. You can keep a car and keep clothes and furniture. And we don't want to put people in the poorhouse anymore. We want to give them a fresh start without basically stripping them of every asset they have. But it's a similar phenomenon for business as well, too. Businesses, when they file bankruptcy, have to pay all the creditors whatever's left, and they can't have a lot of profit to be distributed to their owners, because otherwise they wouldn't be filing bankruptcy. But there is a thing called the Chapter 11 bankruptcy. Sometimes a business is in deep trouble. They can't pay the creditors that they owe at this moment, and they're going in default on loans and debts and things like that. But there's hope. If they are allowed to reorganize and restructure some of that debt in the time it's paid, the company could come back like a phoenix from the ashes and thrive once again. I think Chrysler went through Chapter 11 once. I know Kmart did it several times. They're finally gone. Although I think they bought Sears, but Sears, for example, was in Chapter 11 for a long time. I think they finally converted to a complete liquidation, and I think that's 13 in business. 7 for an individual is a complete liquidation. But when you hear some companies filing Chapter 11, it's not always a death knell to the corporate entity. They might be allowed to be restructured. And that's what the bankruptcy trustee does. They look at the nature of the business, where they're going, and the perspectives for the future. And say, if we restructure some of the debt, maybe reduce some of it, across the board, and maybe just give longer periods of time for the business to pay it back, they will gain viability in the future. And that's what the bankruptcy code for, is not to wipe out things that might actually help society on some level as a part of the business machine, but it's to make sure it's only about when there's viability. Otherwise, it'll convert it to a 13, which is close it out completely. Not going to really spend any time on negotiable instruments. I'm really surprised it's in here. That's business law too, just other than the fact that there are sometimes special kinds of contracts where there's negotiable instruments or commercial paper involved. This is what usually is like things like mortgages, checks, securities, IOUs, all those things where you can make it payable to order. And that gives the person, I write a check to you, Jane Doe, or to her order, pay to the order of Jane Doe, and I sign it. Well, that is coming out. I'm basically ordering my depository institution, a bank, a credit union, or something like that, to give you those funds. And if it's on demand, that's what most notes are, or a site draft, you as the payee, Jane Doe, would present it to that third party called the drawee. The drawer is the person that wrote out the check, me. The drawee is the bank or the financial institution that has deposits of mine recorded there, and you are the payee. So it's the drawer, the drawee, and the payee. And what makes it interesting is you don't necessarily have to go and present it to that drawee. You could negotiate the back of it to a third party. And that's what gives this whole thing of commercial paper special influence, because it fuels business to be able to have negotiable instruments like loans. I take out a loan at my bank to take out a mortgage on my home. The mortgage is a security interest, but the loan is a negotiable instrument, and they sell those sometimes. So, maybe I'm paying 4% interest on my loan, but the market changes in some way. They want to sell some of those securities to third parties. They negotiate it to those third parties, and now they own the right to make a demand on the creditor, me, the person in that fuels a lot of the financial institutions that we think of to this day. I don't want to get too deep in it, but there's all kinds of liability. There's liability for the drawer. There's liability for the drawee, the financial institution, but there's also liability for anybody that endorses the back of the check, which might be the payee or any future endorsers, because there's certain liabilities go back, because at some point somebody might get stiffed. They're trying to cash it, and they're saying, well, now the drawee is rejecting it because insufficient funds or for some other reason. Now, does that person have a right to go to the person that transferred it to him? And that's the analysis we do in commercial paper. If you go into law school, and many of you will, some of you I'm probably scaring away right now, but you'll spend an entire semester on negotiable instruments. It's not that hard, and it's actually a lot of common sense principles involved. And there's ways of getting out of some of the liability, because you can sign the back of a check, James Corman, without warranties and without recourse. So whoever I transferred it to, they're going to go to the bank and try to get the funds. But if it doesn't work out, they can't come back to me because I signed it waiving any potential liability. And so there's liability for endorsers, payees, payors, drawees, and drawers. Don't want to get too deep on it. So we finished that very, very, very boring chapter. Next is chapter 15, criminal law, and my specialty makes me sound like I'm bragging, but it's what I do still to this day. I practice fairly regularly in the criminal court, so we'll put something up very soon. Otherwise, I hope everyone's well.